start. Learned AGA, on the other hand, submitted that the trial court had analyzed the issue in right perspective and there is no contradiction in the medico-legal report vis-a-vis post-mortem report. We have heard the learned counsel for the parties and perused the documents available on record, and we find that the view taken by the court below cannot be faulted, particularly in view of the fact that the court below had meticulously analyzed each and every aspect of the matter and has come to the conclusion that the distance between the place where the victim sustained firearm injuries and fell down vis-a-vis the place where the complainant was present was only 4 steps, being a short distance, and the distance between the place where the victim sustained firearm injuries and fell down the place where accused were hiding was 6 steps. Similarly, the distance between the place where witnesses who saw the incident was present vis-a-vis the place where victim fell down and sustained injuries was 40 steps. Though the court below has taken the view that distance cannot be measured by the steps, as the steps may be differ from person to person according to his height, but the logic so advanced by the court below, while taking clue from the site plan which was prepared by the investigating officer, was with relation to the fact that when gunshot injuries are sustained from the closeness of the person who has fired, then occurs near the injuries. Here in the present case, record reveals that there was burning which was noticed by PW3, being Dr. M.J. Sharma, who conducted the post-mortem, and this becomes a crucial fact that it was a gunshot injury. Even though much reliance has been placed upon the injury report which was prepared by PW5, being Dr. Anil Kumar Gupta, but in the opinion contained in that report, it has been mentioned that the cause of the injury was firearm injury. Even otherwise, the injury report cannot be read in isolation. However, the same has to be read in conformity and in consonance with the surrounding factors, evidences, including the statements of the witnesses. Learned counsel for the appellants have argued that there is a great inconsistency in the version of the prosecution viz the receiving of the injuries, as according to the learned counsel for the appellants, it has been alleged in the FIR and in the statement in support thereof that the deceased sustained injuries in front. However, the deposition of PW5 Dr. Anil Kumar Gupta, who prepared the injury report, reveals that the injury number 3 was sustained at back. Thus, the entire basis of hold the appellants guilty of commission of the said offence, while convicting has no legs to stand. The argument so raised by the learned counsel for the appellants, though appears to be attractive, but it is not liable to be accepted, as it has come on record that the deceased was accompanied with the complainant when the occurrence took place, and the distance between the deceased and complainant was a short distance which was measured to be 4 steps, and when the complainant saw the appellants with the country-made pistol, then the complainant lied down on the surface, and the deceased victim, in order to save himself, would have turned around just to run away while being confronted with the